Hey, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, Lieutenant for the Commonwealth. Draw near, give your attendance, and you shall be heard. I say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. So that's working. Welcome to the Appeals Court. I am Justice Rubin, and to my right, Justice Shin, and to my left, Justice Hodgens. We will be your panel for today. We will be hearing 6 cases. We've had some logistical surprises. So we will be beginning today with what's actually listed as second on the list. It is number 23744, Commonwealth versus Andre. It is partially impounded, and I will remind the attorneys to abide by the impoundment order. And with that, we will hear first, I believe, from Attorney George.
Morning, Your Honors. This is a matter that has been briefed, obviously, by both parties, but quite extensively briefed. And there isn't a lot to say here today that I haven't already said in writing. And at the risk of boring you or at the risk of being repetitive, I just want you to know that there are simply 3 issues in this case. It's a 3-argument case. And it's a case that is basically founded and based on how long it took to get this case to trial, how long it took to charge in this case, and how much time passed in the meantime. This is a case that at the time it went to trial was approximately 32 years old. When I say 32 years old, between 1990 or 1989 and 1994, the alleged victim in this case made allegations that her stepfather digitally and anally raped her on a series of unknown dates between that period of time. At the time that the incidents allegedly occurred, there was a statute of limitations, but in the meantime, the statute of limitations not only was extended, but it was then extinguished. I don't know the year that it happened, but in the meantime, this is not a statute of limitations case because the statute of limitations on rape of a child disappeared over the passage of time in this case. Between 1990 and 1990 and 1994, the victim in this case was approximately 6 or 7 years old. At some point in 1995, when the victim was 12 years old, she was going to a summer camp, and her mother took her to the Bowdoin Health Center in Boston to do a routine physical. At that time, she first disclosed.
Well, we're familiar, I think, with the facts of the case.
Okay.
I guess what I'd like to hear is what the actual prejudice is to your client from the delay.
Well, that's where there's a dispute, and these arguments had been made below, and they're well documented in the record below. During the passage of time that occurred, a key witness in this case, the great-grandmother of the victim, she died.
Well, it's not clear that she was actually a witness to the event. I know you say it, but when I look at the description in the transcript, it seems more like...
Well, being an old trial lawyer, Judge Rubin, being an old trial lawyer myself, a witness doesn't have to be an eyewitness, of course, to be cross-examined in such a way.
No, I agree with that, but in terms of actual prejudice, yes, of course that person has died, okay.
And I don't mean to interrupt you in any way. But
No, please.
Alleged victim
I'm sorry
in
for
this case
interrupting
made allegations as to time, place, means, and manner at 36 Codman Street, where she was living, in her great-grandmother's apartment. Her great-grandmother, supposedly interrupted what had occurred in the apartment between the defendant and the alleged victim.
Even that's a little ambiguous, it seems to me, in the record, but go ahead.
But as far as there was no cross-examination because she had gone. As far as any statements the alleged victim would have made to her grandmother at the time, that was lost in time. Now, there is a dispute here, although below the record is well developed, that records were incomplete or disappeared in the meantime at Tufts New England Medical Center, where interviews were done and evaluations were done. At DSS, where an incomplete record was provided, not necessarily by the district attorney's office, it just was unavailable at the time of trial. And a trial counsel made it clear to the court that he didn't have a complete record, and he was looking for the evaluations and different interviews that had been done during the course of that interview. Judge Hodgens?
On the one hand, I'm sympathetic to your overall argument that when so much time goes by, I'm just putting myself in the position of the defendant. I mean, it's a hard thing to face. How do you defend yourself after so many years? But with the standard we have to go by, we have to look at, okay, is there some intentional or reckless conduct on the part of the government that has brought this about? So if we go back to 1995, when the police first learned about this through DSS, presumably, and you acknowledge in your brief, on page 16 and page 18, you indicated that the mother sabotaged the prosecution. She refused the sane interview. This wasn't going to go forward. The government can only do so much. So I'm curious, what was the conduct of the government at that point in time that was intentional or reckless that made the government responsible for the delay? It sounds more like the victim.
Well, I'm happy that I'm glad that you focused on reckless, because to me it's not necessarily as intentional as it is reckless, because in 2000, in the year that you just talked about, in 95, the victim, the alleged victim, went to school, graduated school, as you know from the brief, was educated, came back a lawyer, and worked in a variety of jobs. At some point in 2015, she approached the Boston police again. Now, in 2016, she was indicted as the defendant was indicted as a result of her reporting to the Boston police 20 years later. The prosecution then didn't proceed to trial in this case for another 7 years. So he wasn't tried until 2022. I understand what you're asking me, but in the meantime, I would suggest that kind of delay, COVID or no COVID, on the basis of the docket that I provided, as well as the Commonwealth provided to you as part of the appendix.
Okay, so now you're shifting to post-indictment delay. I'd like to just ask another question about pre-indictment delay. You say records were lost. You mentioned so far I think it's BMC, whatever, medical records were lost. Was anything else lost?
Yes, Your Honor, yes. According to the record below, DSS records were incomplete, that there were interviews missing, that I don't know what was provided, but there was a DSS report provided because the witness, Patricia Armand, who testified, had written a report. But the interviews, the handwritten notes of the Boston police who decided not to charge in 1995-96, whether the mother sabotaged or not.
Well, let me ask you this about the sabotage question. The judge below, Judge Muse, said that there is, well, actually, it didn't say evidence in the record. It says information that there was a December 18, 1996 letter from an ADA to DSS explaining the decision not to proceed criminally. I don't see that in the record. Do you know what that letter is?
No, Your Honor, that first time that I have not seen that record, and I don't believe was entered into evidence below as an exhibit or for identification.
But you do see that the judge refers to it in the decision below.
I see what you're talking about, Judge Rubin. I saw that mention of it, but I want you to know that that was not in the record that I have. And I'm not saying the record's incomplete. I'm just saying I don't have it.
Okay.
And
was there an evidentiary hearing on before Judge Muse?
I'm sorry, Your Honor.
Was there an evidentiary hearing before Judge Muse?
There was an argument. I don't believe
right.
there
was
an
evidentiary.
I don't believe there was an evidentiary.
Did the defendant ask for one?
Well, trial counsel argued before Judge Muse on a date, and approximately about a month later, Judge Muse made his ruling, but I don't believe any evidence was presented at that, other than argument. And then the argument was made again before trial as to the same issues. And added to that was post-indictment delay, but it was denied again. But as far as getting back to Judge Rubin's question about what was missing, Boston police records, according to trial counsel, Boston police records were missing from 95 and 96. I believe trial counsel was also looking for district attorney's notes as to why they did not charge. There was a whole series of records, and by the way, they're all listed in the argument in the brief as to what the records were, and they're in the appendix. They're listed in the actual motions that were filed below as what.
And did they also indicate that it was non-cooperation by the mother?
No, the problem is the missing records are missing.
I see.
With what we do have, that the fact that we agree that the mother said that she sabotaged the investigation early on, it comes from the mother herself who testified and was interviewed. The bottom line is we don't have any records that indicates anything differently because they're missing, and they're admittedly missing, and I'm blaming that on the passage of time. The prosecution, of course, as they should, reacts to the word intentional. I'm suggesting to you that it's reckless and negligent, and over the passage of time, these kinds of things happen. But these are all things that were argued and arguments that were made and issues that were raised
Right,
below.
but isn't it the defendant's burden to provide factual support in support of a motion to dismiss on this basis? And it's a very high burden. So where's the factual support for either actual prejudice or reckless conduct on the part of the government?
I suggest to the court that the argument below, that the record as it exists below demonstrates what I'm claiming to be actual prejudice in this case, and that the missing records themselves, as well as the missing witness, and the missing witness as a result of death, is something that occurred over the passage of time that would not have occurred had the case gone to trial earlier. Now, can I move over to,
Oh, yeah,
if I may?
I want you to continue responding to Judge Hodgens to the extent you were.
I think you answered my question, but.
Thank you, Judge.
Sure.
As far as the post-indictment delay, I suggest that there was a post-indictment delay of 7 years, approximately 6 or 7 years in this case, during which all of the things I just mentioned to you now that were missing, that had happened over the past.
How much of that time did the defendant acquiesce in?
I actually mentioned it in the brief. I only found 1 or 2 instances of where the defendant
How long did
agreed.
each last? How long did each last?
I think 1 was for 8 months and 1 was for 3 months.
Okay, so about a year.
Yeah.
How long were there delays because of COVID and the courtrooms being shut?
That I wasn't able to determine from the record. But in the other cases that I've been involved in, I've been able to, 2 years is about the amount of time that I was able, in other cases, and I don't apply it to this case, that COVID was something that was causing continuances in the system for almost 2 years. But in this case, we're talking about 73 months. And I'd suggest to the court, respectfully, that that kind of delay is something else that should be considered on the issue of fundamental fairness by this court. As far as the other 2 issues that I raised in the
Sorry,
brief.
before you move on, was that issue raised before the trial court? Post-indictment delay?
Yes, Your Honor.
It
was
was?
raised before the trial judge, actually, Judge Ellis. It was an added argument that was made in the renewal of the motion to dismiss that had been denied by Judge Muse. That was an added argument that was made then. And I'd rest on the brief on my other 2 arguments, Your Honor.
When was that, this renewed motion to dismiss? Was it
November of 2000
before trial?
November of 2022, approximately a week before trial.
I see, okay.
And I'd rest on the brief on my last 2 arguments, Your Honors, because I don't have enough time to finish making both those arguments, but they're fully briefed. Thank you.
No questions?
Thank you.
Thank you very much. We will hear next from Attorney Paris.
Good morning. May it please the court. Molly Paris on behalf of the Commonwealth. With me at counsel's table today is the trial prosecutor, Ursula Knight. I'd like to start with the first issue. The defendant's motion to dismiss and his renewed motion to dismiss were properly denied. If the court would allow, I'd like to start first with the pre-indictment delay and then move to the post-indictment delay. As to the pre-indictment delay, the defendant here failed to establish actual substantial prejudice and that the delay was intentionally or recklessly caused by the Commonwealth. I'd like to briefly note that below, counsel argued that the delay was intentional. Here, he's arguing that it's reckless. But just as to prejudice, the defendant failed to meet his burden. At the outset, all of his claims are conclusory. I'd like to just go through those briefly. As to the unavailability of the great-grandmother, first of all, the defendant failed to establish how her testimony would have contradicted the victim's. But more importantly, she died in November of 1994, which was before the victim disclosed in 1995. As to the missing files, the motion judge correctly found that the defendant failed to establish actual substantial prejudice. He didn't specify how these files would have been relevant to his defense. But
You're talking about all the files from everywhere, or are we talking about the medical?
I'm talking specifically about the alleged missing files and possible from Tufts and missing files from DSS, but also as the record points out to, and as I referenced in my pre-argument letter, the record shows that the defendant received these Tufts records and DCF records under Rule 17. That's all in the docket, which we can presume is accurate. And had he thought there were additional records, he could have filed an affidavit saying, I've received these records, this is what I believe to be missing. He didn't do that here. He received those records, and again, I'd point the court to the November 8th, 2022 pretrial hearing on the renewed motion to dismiss where the Commonwealth represented. All those records are available to the defense and have been provided. There's no objection from defense
All the
counsel.
records that are available have been provided.
Correct, he had all
Yes,
the...
but isn't his concern that there are records that are no longer available?
That is possibly what he's claiming,
I
but
assume that's what he's claiming, because the ones he has, he has.
he has everything that was available. Should he have thought there were additional records out in the ether, not only did he not show why those documents, would have been relevant to his defense, had they shown an actual prejudice to his defense, but also there's nothing in the docket to suggest a motion to compel. There's nothing to suggest that he requested an evidentiary hearing to call in someone from...
So what about police documents that I was asking your colleague about? Documents explaining the reason for non-prosecution.
The defendant, he had this letter. It was mentioned in Judge Muse's...
He has the letter? Do we?
No, because the defendant never provided, as was his burden, a transcript from the 2018 motion to dismiss hearing before Judge Muse.
Well, a transcript isn't the same as a letter.
Those items were referenced at that hearing, but in addition...
Were they introduced as evidence?
I believe they were. But again, that was the defendant's burden to provide that transcript. He didn't provide it.
Do you have the letter?
I do have the letter.
You've seen it?
I have seen it. They're in the documents. And also, I'd point the court to the renewed motion to dismiss hearing from November 8th. And in paper 70, which is noted in the docket, that letter was attached. The defendant attached that letter. So he has it.
Where is it?
It's not in the record. I'm happy to provide it to your honors.
Wait, I don't understand. So what is it? How it's attached to the motion to dismiss?
It's not, no, it wasn't attached to the motion to dismiss. In the pretrial hearing, there's reference at the outset of that transcript where he's referencing this letter, and he says, I have it.
Do we have the transcript?
From the pretrial hearing?
The one you're talking about?
Yes.
We do?
Yeah, the November 8th, 2022 pretrial hearing.
Okay.
But regardless, I think that goes more towards the Commonwealth putting forth something, not the defendant meeting his burden of showing actual substantial prejudice from the absence of these documents. And again, there's no affidavit from the defendant. Defense counsel's affidavit says nothing further on the issue of prejudice than what's already in the motion. And that was before Judge Muse and Judge Ellis, and both correctly denied the motion to dismiss on those grounds.
Is your position that some police records have been lost with the passage of time or not?
No, Your Honor. And from my understanding, the police never got involved in this case.
Okay, then district attorney's records, are they lost? Or you have all of the DA's records from 1990, whatever it is, 5 and 6?
We have the records, and that's discussed at...
But there's nothing in them about why this wasn't prosecuted back then.
There is, the letter, and we know that this wasn't prosecuted.
That letter was in the DA's files.
Yes.
So it was under Brady, it was turned over.
Yes, it was. And that letter just simply explained, as was relevant also in the grand jury minutes, which Judge Muse references in his ruling, that the Commonwealth could not proceed with the prosecution because the mother didn't want to bring the victim in for a forensic interview and proceed with the prosecution. So the defendant had this information. And then lastly, just turning to the defendant's faded memory, again, this is a self-serving assertion, and the case law makes clear when we look at Fayweather, the defendant's alleged inability to recall his whereabouts at the time of the incident does not constitute severe prejudice. And again, I'd like to emphasize that this case was fairly intact despite its age. Aside from the great-grandmother who died prior to the victim making the disclosure in 1995, all of the witnesses were available, including Patty Arman, who was the original DSS investigator who testified at trial for the defense. And again, all of the records, the Tufts records and the DSS records were available. That's noted in the transcript. And again, these were Rule 17 records that were at the clerk's office that the defendant requested and could go access. And then if the court would allow, as to the reason for the pre-indictment delay, I think Commonwealth versus Dame is instructive.
Let me ask you about that. Let me ask you about Dame, because there seems to be a distinction in that case that Justice Cordy focused on, and I wonder if it makes a difference here. In Dame, we had a long delay, as in this case, but it was as a result of a change in DNA technology that enabled the prosecution to go forward. And when the justices were trying to evaluate whether or not there was prejudice, one of the factors they considered was that the quality of the evidence was so compelling that it was this DNA evidence that really zeroed in on the defendant as the perpetrator. But we don't have that in this case. All we seem to have is a testimony of the victim, which of course can certainly carry the day, but is that as compelling as DNA evidence when we're evaluating the question of prejudice?
I mean, forensic evidence would certainly make a case stronger, but there's no indication that that would even be the case in this case, where, again, the victim made a delayed disclosure of the sexual abuse that occurred between 1990 and 1994. So there's nothing to suggest that there was forensic or DNA evidence that would have been available had this case been brought, at the time of the original disclosure back in 1995. So I don't know if that's directly on point. But I would like to point to Dame as to the reason for the pre-indictment delay, where the court said that such a conclusory statement will not suffice to meet the defendant's heavy burden of providing a constitutional deprivation. And that's exactly what we have here, is just the mere assertion that the delay was intentional, or as counsel claims here, reckless, is not sufficient to meet his burden. And again, any reference to the victim coming forward later doesn't have any bearing on whether the Commonwealth has any intentional or reckless part in the delay. To the extent the defendant's also challenging the post-indictment delay.
I want to stick with pre-indictment for another minute. So I just looked at the references that you described to this letter, and at least below, counsel's argument for the defendant was, the letter says they're conducting an investigation. It begins, the district attorney's office is conducting an investigation. We got all the files from the district attorney's office, but there's nothing about the investigation in there.
Correct, Your Honor, and there was nothing about the investigation because all that happened was that the victim made a report to her pediatrician in mid-19...
Nobody typed that up.
Those would have been in the medical records that the defendant received.
You don't think the district attorney's office, when they begin looking into this and do interviews and so on with the mother, they don't keep notes of that?
I mean, any notes as the Commonwealth represented at that hearing would be subject to the work product doctrine. And that was offered at the hearing. But there was police never got involved in this case.
I'm asking about DA records.
There were none. And the Commonwealth makes that clear, I believe, at the...
How do we know that? How do you know?
I mean, I know as an officer of the court and speaking with the trial prosecutor and also...
How does the prosecutor, how does anyone currently in the DA's office know?
This
It's
is
a
the-
file from 1995.
This is the original trial prosecutor, Your Honor, from 1995, who handled this case.
Why was there a trial prosecutor in 1995? I thought we didn't proceed with a...
There was an initial investigation into this case.
Yeah.
There was grand jury, and at that point, there was no longer any further movement from the prosecutor's office because, again, the mother did not want to proceed with the prosecution. Her daughter at the time was 12 years old.
Mm-hmm.
And again, all this information came up at trial, so the jury wasn't left wondering.
Well, that's not, I mean, the question is, I don't know how someone proves prejudice from something missing. That seems like a trap to me, although maybe it's the law we have to apply. If someone says to me, well, I don't have any of the records, and I say, but that would show the fraud you committed, and they say I don't have any of them, I don't know how I'm supposed to prove prejudice from their loss. So I'm not even sure how that's supposed to work, but I'm trying to figure out how I know if something's lost or not. Now you tell me you have a representation from the person who was the prosecutor in 1995 who did this investigation. Did they testify?
Did they testify?
Yes, did this 1995 prosecutor testify? Were they called as a witness to talk about the investigation?
No, they weren't called to testify about the investigation. They were the prosecutor who was present before Judge Ellis at the pretrial hearing in November 8th of 2022. But again, this is in the file. If Your Honor, I'm happy to submit a 16L or something to provide with the court. But again, I'd submit this is, the defendant's burden where this was raised at the motion to dismiss hearing, and he did not provide a transcript from that hearing. And that was what was presented to the panel here.
Are you saying that the DA's office back in 1995, that the machinery of prosecution never got cranked up because right at the beginning it was made clear that the victim and her mom in particular are not going to cooperate? Is that...
Yes, that's exactly correct, Your Honor.
So how can there be a trial prosecutor?
There was someone assigned to the case from the district attorney's office because, again, there were grand jury minutes, as was referenced at the motion to dismiss hearing, and Judge Muse referenced those at his...
There's no evidence that this December 12th, whatever letter it is, was written by that person, is there?
There is, yes.
That person wrote this letter?
Yes.
What's the evidence of that?
I mean, as an officer of the court, I've read this letter, but again, Judge Muse references...
I don't care what Judge Muse referenced. I'm asking what evidence there is that this prosecutor is the one who wrote this letter.
It's in the record.
What's the evidence that's in the record? Is this letter signed? I thought it was a draft. I thought they couldn't even figure out who it was to.
They couldn't find out who... It was a draft letter. Again, that's because...
Well, they could have asked the person who drafted it.
No, it was a draft, right, it was a draft letter, and the prosecutor's name was there, but the issue that was raised at the pretrial motion to dismiss hearing was that there wasn't, the Commonwealth wasn't willing to provide the final letter that was being sent to the mother because that was a witness, that was a potential witness in the case at the time. But this letter is in the file.
Wait, I'm sorry. I don't understand what you're saying. You didn't turn something over in discovery because...
Everything was turned over.
Not this signed letter, apparently. You have the final letter but didn't turn it over.
The letter is in our file, and it's referenced in paper 70, which the defendant references at the pretrial motion.
Paper 70 is? Paper
70 was a Rule 14 discovery request And the defendant is, requesting, there's discussion of that letter at the outset of the pretrial.
Of the signed letter that you're not turning over?
Yes.
Okay.
I see that my time has expired.
Time has expired, but I see no further questions.
Thank
You
you.
very much. Excellent arguments by both of you, very helpful to us. The case is submitted. I'll be corrected if I'm wrong, but I believe we're now going to hear what was the first case. Is that right or no? Yes. Third case, first case. No, Lopez. Okay. So we're going to hear number 22-821, which was the first case on the list. And it is Commonwealth versus Lopez. And we will hear first from Attorney Medeiros.
Good morning, Your Honors. May it please the Court, Lisa Medeiros for Mr. Bruno Lopes. Your Honors, the cumulative effect of the prosecutor's erroneous statements in both his opening and his closing arguments were overwhelmingly prejudicial, and I would suggest left an indelible imprint on the jurors' minds, one that they were not able to let go of. The reason that I'm suggesting that the statements were so impactful is because they went directly to the heart of the case. The very critical issue in the case was Mr. Lopes, the shooter in the Temple landing video, who was wearing shorts? That was what the jury had to decide. As you know, the videos were not clear enough for somebody to look at it and make that identification. So there was a pretrial ruling where the trial judge said nobody would identify Mr. Lopes in the videos. Despite the clear ruling, the prosecutor said on 3 occasions in his opening that Detective Wadman saw the defendant in the video, unequivocally.
In the videos before the shooting, he didn't identify the defendant as the man in shorts, right?
Did you say in shorts, Your Honor?
Yes. He said he was one of the 4 men seen in the videos getting into the taxi, getting out of the taxi, walking from Oliveira's house.
Correct.
So Oliveira testifies that the defendant came to her house with 2 or 3 other men, left shortly before the shooting. What's the argument that the defendant was not one of those 4 men? That there were 2 group of men who came to her house?
Well, I would suggest that that was something that should have been left to the jurors to determine.
Right, but we're trying to decide whether there is prejudice from these statements. So without any reasonable possibility, the jury would have found that the defendant was not one of these 4 men. It's hard for me to see how the statements in the opening were prejudicial.
I do think that the evidence was not overwhelming connecting Mr. Lopes to the videos. Now, I know this court found that there were inferences, and I'm not disputing that at all, that there were inferences whereby you could connect many of the inferences, a chain of the inferences, to come to the conclusion that Mr. Lopes was in the videos. But it wasn't an overwhelming case of concrete evidence where there was an eyewitness who saw him at the Temple landing that testified, somebody saw him in the shorts.
Well, putting aside the Temple landing video, how is he not one of the 4 men? There were 2 groups of men who came to Oliveira's house in a taxi cab and then walked away right before the shooting. One who presumably, if the jury can see the defendant, looks a lot like the defendant. I'm not seeing how it's really a contested issue whether he was one of the 4 men. I see how it's a contested issue whether he was one of the shooters.
Well, there was a ruling in this court that said that there was sufficient inferences to determine that he was the shooter, but I would suggest that at the trial, the jurors had to conclude that, and I think that there was a question whether or not.
Okay, so let's get back to the actual statements that are allegedly harmful. It seems to me there is sufficient evidence that he was there. The shortest way I can put it is he said, I was there but didn't shoot anyone. And I understand that if there'd been a large crowd of people who were there, we might have said, I guess he could be in the crowd. But I've watched the video of the shooting, and there's nobody there except the four of them. So if he was there but didn't do the shooting, it's not an inescapable inference. Maybe he's out of the frame. Maybe he's, but it's a reasonable inference that he's one of the four. But I thought the critical question was, is he the guy in the gray shorts who does the second shooter? And my understanding is the prosecutor reasonably, because this is what the witness Oliveira had said previously, told the jury at the beginning, you're going to hear that he's the one in the that he was wearing shorts that day. Okay, so that's not an error.
No, I agree with you there.
I mean, it may play a role in the subsequent error because now the jury has been told this, even though she doesn't say it. So what is it she said? She said he was identified in the video repeatedly. But you got this kind of, well, I don't know if it's strong or not. You got a curative instruction.
Yes.
On that.
Could I just make one comment on the defendant's statement about I was there?
Yeah.
There's an important distinction. The statement was, I was there at Temple Landing. Temple Landing is a housing project. The statement wasn't, I was there at the shooting. And I think that's an important distinction because...
Only statement I saw was just, I was there. I don't see that's, where do I find that? I think at trial no one said I was there at Temple Landing, did they?
I know that it was in my brief for the Rule
Okay,
25B
we'll look.
too, and I'm not sure that it's in this brief before the
Okay.
court right now.
Whatever, this is, you're collaterally estopped from, right, I mean, a panel of this court has found.
Yes.
All right, so,
And
okay.
he said that he was there.
Okay,
Yes.
so, but the real question remains, I think, given what our prior panel said, was he the guy in the shorts, and is there, they say there's sufficient evidence, but did these errors affect that, a jury's conclusion about that?
Yes.
Now, I'm not sure how saying he was identified, in opening, the prosecutor doesn't say he was identified on the video as the shooter.
No.
Just that he was identified on the video, and then there's this curative instruction. Now, maybe it's insufficient, maybe it's not, we'll have to sort that out.
Well, and with respect to putting him in the shorts, that is, and that's why I'm saying the cumulative effect of these errors, as looked at as a whole, is a problem. Because the prosecutor, rightfully so, says that he expected the evidence to show that she would say that he was in shorts that day. She doesn't testify like that. She says everybody's in black. And then in his closing, there's a clear implication when he says, I asked her about Mr. Lopes being in the shorts, and she couldn't remember, and she couldn't remember a lot of things, which implied that Ms. Oliveira had said at a previous time.
Yeah, I see that argument. I understand that argument.
Well, and I'm suggesting, Your Honor, that when you combine it with what I'm calling the errors from the opening, it's very prejudicial.
Well, certainly with it's not an error from the opening, but certainly when he says in the opening, this person said he was wearing shorts, and then she doesn't. She says, shorts? I don't know. I don't remember that. And then he says, she said she didn't remember the shorts, implication being, but she said it before. The but she said it before is not in evidence because the judge didn't allow in the prior statement
Right.
for any purpose on the ground, I guess, that it was coerced.
That's right.
I mean, I don't know anything about that, but that's what the
Right,
judge
that was
did.
the ruling.
So there's no affirmative evidence of him being wearing gray shorts. And even our prior decision doesn't say there's evidence of that. They talk a lot about comparing the skin colors of the different people and so on. they do it sort of obliquely for some reason, but that's what they're saying.
Yes.
They're saying you could look closely at them, see he's the darkest skinned one, and so if he was there and is the darkest skinned one, if the jury concluded, I mean, I haven't compared skin tones of all of the people, and I'm not sure if it's clear enough even to do that. But the prosecutor didn't argue. He mentions complexion at one point, but he doesn't say to them why that matters.
No.
He seems to shy away from it if it's in there. I think maybe it's in there, but he doesn't connect the dots for anybody. He says, you can look closely at this. Then he says something that I think is wrong. He says, if you look closely at the video, maybe you can make out facial features. And the answer is like,
You can't.
no, you can't. But okay, whatever. I guess that's not an unfair argument. They've seen the video. But he argues, compare the clothing. But there's no evidence that he was wearing any particular clothing.
Well, and I think that it's...
Maybe something black, but...
It's such an important point, because when you draw the connection with all of the inferences, they say that Mr. Lopes was the one that got in the Bluebird taxi with the darkest skin, and at the Rivet Street video, you can see somebody in shorts with darker skin. So when you start connecting all of these dots, and then you say, well, there's one guy in shorts, and maybe he was the one in the darker skin, that's why I say it's so prejudicial, and that there's
All
something
right,
that the juror
but
could not...
Olivera was asked on redirect examination, did you tell the police before that one man was wearing an orange shirt and one man was wearing shorts? And she says, I don't remember. That was not objected to, it came in.
Right.
So what's the error in the closing? I do think there's a factual error in that in closing, the prosecutor said she didn't remember whether she said the defendant himself was in shorts. Putting that aside, she was asked about the orange shirt
Yes.
and the shorts. So why couldn't the prosecutor comment on her lack of memory about those details?
Well, because she never said that there was no questions about the shorts, so...
There was a question about the shorts. The question was, you don't remember giving a different description regarding basketball shorts. She says, I don't remember. So why is it improper for the prosecutor to comment on her lack of memory?
Well, it's improper to have asked, I would suggest to even have asked that question.
Okay, but it wasn't objected to, so it's in
Right.
the evidence.
Well, so then I would say to then comment on a mistake that he made that wasn't objected to at trial.
No,
and
wait,
to-
that's not affirmative evidence that she did say it. The only evidence is she doesn't remember saying anything about that. You could ask her, did you mention the Red Sox score? And she would say, I don't remember that. That doesn't mean there's evidence that she mentioned the Red Sox score. The judge didn't let in for its truth, which maybe he could have, except he says it's a hearsay matter. Maybe with her not remembering, maybe you can bring in this prior recorded recollection, whatever it is, right? But he didn't allow that.
No, but then the prosecutor did pose it in a question.
Yes, the prosecutor can't put evidence in by putting it in a question.
Well, I would suggest not, when the judge says there's nobody that's going to suggest that Miriam Oliveira said that Mr. Lopes was in shorts that day. To ask that question, I would suggest is improper, and then to
Wait a
comment
minute,
on
why?
it.
Why is that improper? A witness has taken the stand. The prosecutor clearly expected the witness was going to testify about the shorts, based on what he said in the opening. She takes the stand, and she goes south on him. And suddenly she has a loss of memory. And even the judge said, he came to the conclusion, she's feigning a loss of memory. So suddenly she doesn't remember, but she does remember some things. Everyone's wearing black. Now, the prosecutor, when he is asking this question, doesn't the prosecutor have every right to say, well, wait a minute, and to go even further and say, didn't you previously tell the police that he was wearing shorts? And if she says no, then he's stuck with that answer.
No, because there was an entire hearing on whether or not that information was going to come in. So for the prosecutor to pursue that line of
Okay,
questioning.
but you don't need to win on whether it was a good or a bad question. it didn't produce any evidence that he was wearing shorts. Maybe it was a good faith effort to jog her memory or something, although there's other ways you're supposed to do that, right? But asking her on cross-examination about something you have a good faith reason to, is it true you were arrested in 1998? You know, no, people will say, but if there's a good faith basis you can ask, it seems like it's an okay question to me. It just doesn't help the prosecutor at all because she did not remember. So there is no evidence in the record that he can rely on in closing that the guy was wearing gray shorts. I mean, I don't think you need to win this fight. Maybe I'm wrong.
Do you think this argument, the part of the argument, did you push further about, did you see an orange shirt she couldn't remember? Is that improper?
No, because it wasn't part of a pretrial ruling by the judge that that kind of evidence should not be presented to the jury. That was not subject to a pretrial
The whole
ruling.
statement, I thought, the statement to the police, the judge said couldn't come in.
No, it was, the issue was whether or not her statement that Mr. Lopes was wearing shorts. I see what you're saying, Your Honor, that,
All right, since you're running out of time, can I ask you about prejudice?
yes.
How do we determine whether this was, assuming there is error, was prejudicial if we can't tell how easy it is to identify, easy it would be for the jury to identify the defendant based on seeing him in the courtroom?
I would suggest that the case of Commonwealth versus Clary, I cited that in my brief, that it was an evidentiary identification case. The evidence wasn't overwhelming, and I'm suggesting it wasn't overwhelming here. There were statements that were made that were prejudicial, and I would suggest, just like the trial attorney said at trial, you can't unring that bell.
All right, well, I disagree with something that was said before. I forget whether you said it or Justice Rubin said it. I can see the facial features of at least two of the men quite clearly in the Rivet Street video. I can,
The one where they're walking down the street and go into some building.
right. I can see them quite clearly. I can see the man wearing shorts somewhat clearly, especially from the still photo. I can see the fourth man's face partially. You can see the complexion of all four men. Without knowing what the defendant looks like, which the jury had the opportunity to see him in the courtroom, how do we know whether the error was prejudicial, if there was error?
Well, I'm just suggesting that because the evidence was not overwhelming and because the statements were so egregious, that there was no way for the jury to forget those statements. And
What if the videos showed that the man in shorts was 7 feet tall and the other three men were normal height?
Well, that would have been a much clearer case.
Yes, right. So, and in the courtroom, the jury sees the defendant is 7 feet tall. So how do we know?
Well, and if I, you know, if I go back to the statement of him being at Temple Landing, that was up to the jury to decide that. And how do we know? How do they connect him to the shooting? I would say those statements tied up the Commonwealth case and in a nice bow and fill in the gaps. So thank you very much, Your Honors.
Your time has expired. No further questions, I see.
Thank you very much.
Thank you very much.
Thank you.
We will hear next from Attorney Nadeau.
Good morning, Your Honors. May it please the Court, Steve Nadeau on behalf of the Commonwealth. First, I apologize for my tardiness this morning. The red line got me, and I apologize to counsel, too. Turning to the first issue regarding the opening statement, I acknowledge that the prosecutor's comments could have been better phrased to avoid any concern that he was making an improper statement based on the identification evidence or what that would turn out to be. But to the extent there was any issue there was an objection, and the judge gave a prompt instruction that followed after the opening statement. It was explicit, direct to the error that was raised then, raised here now. And I think under Hoylett and Borodine, the promptness and the explicitness of it were sufficient to cure any prejudice. But again, the prosecutor did not explicitly say or misstate that any particular witness was going to say, I identified him in the video, or would be identifying the defendant in the video, or anyone in the video. He just said, as was consistent with the theory, that the video, that the defendant is in the video. And of course, that was the theory that was supported by the evidence, and the previous panel, again, agreed that the evidence supported that theory. Turning to the comments about Ms. Rivera, both in opening and in closing, obviously, based on her statement to the police, there was a reasonable expectation that she would testify consistently with that. Of course, she did not. And she claimed not to remember. There was a finding that she appeared to be feigning memory loss, and that she was reliable on the stand even in court. So that, I think, her credibility was a fair comment to the extent that her statement, they were all wearing black, I don't...
All right, let's say she was not credible. She says she doesn't remember, ladies and gentlemen of the jury, but she's not credible. Let's put her to one side. Now we do this. What's the, I don't understand why that's important to the prosecution. She's lying about not remembering. Let's leave out the fact that specific questions about specific things were asked her. She doesn't remember anything. That's her testimony. Okay, so what? So now you don't have her, she was a valuable witness, but she's done. Right? What difference does it make when you say to the jury, just to begin with, she was lying? What did she say that was helpful to the defendant that you shouldn't believe?
Well, they were all wearing black. I agree that the defendant was basically wearing black. As I recall.
One of them was wearing an orange shirt, maybe, right? So
they were all wearing black, so by implication, they're not the four men in the video. The defendant and the 2 or 3 men who came with him were all wearing black, so they're not the men in the video because one of them was wearing an orange shirt.
Well, that, and I think her testimony was also consistent with placing them there at the time of the video, showing these 4 men.
All right, but that's, so you don't have to show, you want them to think she's credible about that. You're the prosecutor, right?
Point,
so going out and saying she's not credible, that doesn't help you. Okay, she's not credible about not remembering. How does that help your case?
Because if the jury, not, whether they believe her totally, but just is there reasonable doubt, if, she is creating this vagueness, perhaps intentionally by this feigned memory loss, as to what he's actually wearing, that muddies the water for the Commonwealth.
Muddies the water?
Yes, because...
Okay, so what is the affirmative evidence that he was wearing gray shorts, that she's muddied?
The video evidence.
But we don't know that it's him. We know the shooter was wearing gray shorts. What is your affirmative evidence that the defendant was wearing gray shorts?
I would say that would be, again, the video evidence beginning with at Rivet Street, where you can see I think it's there particularly, you can see the defendant partially in profile, where again in the previous...
So when you say in closing, or whoever did the closing says, she wouldn't admit about the gray shorts. She said she didn't remember. The implication is that when she didn't remember, she was not remembering something that she had said before, gray shorts.
I don't think so, because...
Well, he had said at the beginning they were going to hear about gray shorts from her, and they didn't. But then he comes at the end and says, you didn't hear about gray shorts from her, but she was lying.
But they did see the video.
But the video doesn't get you, doesn't have anything to do with her testimony, right?
Not
the video itself. The fact that she doesn't say gray shorts, if that is not credible, the implication, fairly obviously it seems to me, is she did see him and he was wearing gray shorts. But there's no evidence she said that before because of the coercion that prevented her prior statement from coming in.
But and I disagree, because there was evidence that she did see him based on the video.
Wearing gray shorts?
Yes. There's not evidence that she said he was wearing gray shorts, but there was evidence, in fact, that he was wearing gray shorts. That's the video evidence.
You don't need her at all for that. Let's remove her from the case. Now you've got the video evidence, and you say to them, see, it was him wearing gray shorts. Because she's added nothing. She's off the table with respect to gray shorts because there's no affirmative evidence she saw him with gray shorts or said, well, you said, or the prosecutor said at the beginning, you're going to hear it from her. But that's not evidence, that's the prosecutor, and the prosecutor's question about gray shorts is the prosecutor. Now, he keeps saying, compare the clothing, compare the clothing. Well, if they can already identify him as the guy in the gray shorts, they don't need to compare the clothing, they know he's the guy in the gray shorts. Why is the prosecutor saying, compare the clothing? Doesn't it have to be because he's asserting that there's some evidence, which there isn't, that the shooter in the gray shorts is the defendant? Why else would you be comparing the clothing?
Well, I think that's because of the different videos in the case and the different quality and distance of the video. So the moment of shooting, obviously, all the parties are far away. So you from Rivet Street to when they get in the cab to when they get out at Ms. Oliveira's house.
I guess if you see him wearing the gray shorts and he gets in the cab with everybody and then they come out of the cab and go do a shooting, the guy in the gray shorts, unless they've done something crazy in the cab, is him.
Right. But again, on balance, where it's the video of them going to her house, she acknowledges, and leaving her house, and she acknowledges, yes, he was one of these guys there that day. And given her demeanor on the stand, and perhaps her bias in being a friend of this guy, describing him as a brother, you can comment, why is she appear to be feigning memory loss as to what he was wearing when you can see yourselves what he was wearing that day? And I think that's a fair contrast based on the evidence, not based on a reference to excluded testimony.
She knows he was wearing gray shorts, but she won't admit it.
I think that's a fair inference when, and we have indication on the record that she does appear, again, to be feigning memory loss, not just saying that she doesn't remember, and that she is unreliable. So I think that becomes fair comment, again, in context with the video evidence.
So before the prosecutor makes the contested statement, he says, she's asked several questions of what the people were wearing, and I believe your memory controls, but I believe she says they were all wearing black. The implication there, in my mind, is that he wasn't one of the four men at all, because they were all wearing black, and one of the men was wearing orange. So then the prosecutor goes further, says when pushed further as far as asking that Bruno was in gray shorts, she couldn't remember. Pushed further about, did you see an orange shirt? She couldn't remember. Did you see an orange shirt? She couldn't remember. Seems to me to be proper. The error I see is that she was asked on redirect, do you remember saying one man was in orange shirt and one man was in basketball shorts? She was not asked, do you remember saying the defendant was in basketball shorts? Would you agree that that's a misstatement of her, what she actually testified?
I think to the extent that she testified, I don't remember anyone wearing a shirt. She did not say, I don't remember the defendant wearing one. I think that, again, in context, is a sort of minor misstatement. The prosecutor, has been driving at this point that the defendant is a man in shorts, the shooter in shorts, and is just sort of in the process of making that argument.
It's not minor, right? It's identifying him as the shooter if the jury can see that one of the shooters is wearing shorts. He was the only one wearing shorts.
Right. And I guess I would just, again, in the context of closing, it would be, again, just excusable rhetoric in the context of pushing that forward. But no, but
it's not
objection.
Rhetoric, it's an argument.
Okay, sorry, I did draw an objection.
Right.
So there was no evidence before the jury regarding Oliveira's statement to the police?
Correct.
So it seems to me that the prosecutor was not referring to Oliveira's statement to the police, which wasn't even before the jury. It seems that he was referring to the videos to say, well, in fact, I think he said this exactly. You can believe some of what Oliveira says, but not all of it. So you can believe 4 people showed up before the shooting, and one of them was the defendant who showed up. That part you can believe, but don't believe the part about they're all in black because the video shows one guy's in orange. And don't believe what she said or her denial about the shorts because the video shows that someone's wearing shorts. Is that the essence of your argument?
Yes, yes, Your Honor. And so I think, again, in the kind of context of making that point, our theory, the evidence shows that the defendant is wearing shorts while, again, that slight deviation from the testimony, I think it's clear in context that again, and then the prosecutor went on to, tell the jury, you look at the video, you decide, you make these comparisons. And
let me ask you this too. This is an unrelated question, but it caught my eye, and I think the judge dealt with it, and it's certainly not an issue, but it concerned me. During the sidebar, one of the sidebars, the prosecutor, there was a discussion about the 911 recording and the late disclosure of that, actually during trial. And it wasn't just that it was a 911 recording, but it would appear to have been exculpatory because the caller said the shooter was the person in the orange shirt or hoodie. But the prosecutor's response disturbed me because the prosecutor said essentially, well, I notified counsel that, we had all this material, but she never asked for it. I mean, that's not Rule 14, right?
Yes, I agree. And
okay. So the judge dealt with that in his own way, but
yes.
It just troubled me that that was the position the Commonwealth was taking, and you're disavowing that.
Yeah, and unfortunately, where that's not directly raised here today, I didn't speak with the prosecutor about it, so I'm not sure exactly what may have been in the background.
There's an obligation to make sure
Yes,
the defense has
absolutely.
all of the material before trial, and it's not just saying, oh, we have it, if you want it, you can ask for it, right?
Yes, and I do know from experience that this particular prosecutor is very responsible as his obligation. So I think there must have been something else going on that I can't unfortunately speak to, not apparent on the record today.
Okay, thank you.
But you're right, Your Honor.
So, the judge entered required findings of not guilty in this case on both counts.
Yes.
And the judge said, I'm now reading from our opinion, the judge said that there was no evidence that the defendant owned the clothes depicted in any of the video footage, or that anyone had seen him in those clothes on the day of the shooting. Okay. We don't overturn that finding. The Commonwealth doesn't rely on it. No. We say the Commonwealth argues that there was sufficient evidence to identify the defendant where the evidence established that he was one of the group of 4 men. We're going with that assumption for this purpose of this argument anyway, and that he must have been the second shooter because he could not have been any of the other 3 men in the group. That is not, you could include him because he had gray shorts, but you could exclude everyone else, so it must be him, right? That's what we say. So I don't understand the constant reference to the clothing. The judge says there's no evidence that he had shorts on that day, and we don't say otherwise. We don't rely on that at all. We rely on, well, he couldn't have been, we rely on skin color, basically. He couldn't have been this one, couldn't have been that one. He's not the 2 white guys, and he's not one of the 2 people of color. And we say there's enough evidence that he couldn't have been the lighter-skinned person of color, partly because of what the taxi driver says. And then I don't know if that's all right or not, but that wasn't the argument that was made by the prosecutor. The prosecutor's argument was compare the clothes.
Well, also, I obviously, we did not disagree, we did not agree with the judge's finding.
I agree with that.
And I would say that the prior panel I think it's at the top of page 6 in the decision, says that the jury could make the positive comparison, not just based on complexion, but based on the facial features that were visible, and that they could then go on to say they could also make the negative inference. That you can make the positive
I don't see that. What we say at the top of page 6 is, significantly, the jury could also compare the defendant's appearance with the other 3 men depicted in the visual evidence and exclude the possibility that the defendant was the first shooter, the man in the orange shirt, or the man in the maroon pants. Well, they're both white, but let's keep going. In addition to what the jury could see, they could have relied on the taxi cab driver's testimony that his skin tone was darker than that of the other 3 men. Using this process of elimination, the jury could have found the defendant was the man in the dark shorts and striped hoodie, and therefore the second shooter.
And I would disagree. I think the sentence before that the jury could compare the defendant's appearance in the courtroom and the appearance of the second shooter and consider that they were consistent.
Yes, but he wasn't wearing shorts in the courtroom, right? Because he's not an idiot.
No, but he is the guy they're comparing to who is wearing shorts. So
I understand that there's lots of ways that if you find the second shooter, you find someone wearing shorts. That's clear. The whole question here today is about this closing argument and the reference to shorts in it.
And then I would suggest that the evidence that Ms. Oliveira saw the defendant wearing shorts that day is that there was a video of him wearing shorts walking into her house, leaving her house, and she testified again that he was there. She acknowledged that he was there and appeared to be feigning memory loss when she said she couldn't remember what anyone was wearing.
I mean, maybe the jury has miracle insight into what was meant. I'm just looking at the words on the page.
Sure.
All right, do you have more?
No, thank you.
Okay. I see no further questions. Thank you very much. Excellent arguments
Thank you.
by both of you. The case is submitted.
Thank you very much.
The next case we will hear, if I can find my sheet, is number 23-903. This is Lovejoy versus Commonwealth. It is a partially impounded case, so I would ask the council to adhere to the impoundment order. We will hear first from Attorney Burkholder.
Good morning, Your Honors. May it please the Court, Attorney Fred Burkholder for the appellant. The case is well briefed, but the issue is the same as it is in most of these Section 9 cases, which is, was there adequate progress in treatment? I submit in this case, there was. And the evidence that I point to is highlighted very accurately in my brief, but I'll gloss over it for the Court's review. First of all, he's been in treatment for 14 years. By the time it was 2015, he was doing so well that he was placed in the treatment house, not a place where most of these guys get to. He gets there. Of course, he makes a mistake, he plagiarizes, he has some issues with getting along, he gets kicked out. He returns to treatment. He's doing well again in treatment. This time COVID hits, and he doesn't want to subject himself to potential mask issues, and more importantly, he has a conflict with another individual. He approaches that with the counselors. There's no alternative for him. He withdraws. He returns to treatment, and even when he withdraws, he continues moving on with his progress. When he comes back, by all accounts, everybody says he's progressing well, and they even make him a peer aide. So now we have a guy that's 62 years old, been there in custody for 32 years, he's been in treatment for 14 years, and even one of the qualified examiners, and I believe it was Cookman, says it's unfortunate that there was the interruption. I submit that the test isn't whether or not he completes treatment, the test is whether or not he reaches the level where he has interventions that he can use. And in that regard, I direct the Court's attention to what his expert, Dr. Brown, said, which is as follows. The Commonwealth's experts failed to properly consider that all of Mr. sex offenses occurred over 32 years, that ASPD remits with age. He has been He has been OBR free for over 10 years, has engaged in treatment for many years, has by all accounts made considerable progress, learned to recognize when intervention is required and how to do it, and acknowledge that his treatment has already resulted in a change of how he feels about himself and wants to treat others. That's not my only argument, but that's part of it. The other part of it is, this case is obviously about the last two elements. My expert says there's no mental abnormality, nor is there a personality disorder. The qualified examiners say both sexual sadism as well as pedophilia, but they admit on cross-examination that with treatment, those can be resolved. I think Cookman even says, Calistria even says ASPD isn't even present. So not only do we have an issue whether or not age has affected that, but we have to go back to the original test of Butcher, which is the likeliness test, and there are three components, as the court is well aware. The second of those components is a relative certainty of committing another offense. And I direct the court's attention to the static 99R test. Nobody that I've represented in the last 10 years has had a 1. Nobody. Now, I know my brother is going to make the argument, which says, of course, that not all offenses are, unless convicted, are considered, and multiple offenses are considered under the same consideration and the like. First of all, my argument to that would be McCool says you can't consider offenses that were not convicted in this setting, and I'm no expert on the case law in this, as I try to be in other areas, but I believe that's the case. But more importantly, at a level 1, his risk is 3 to 5%. So we have to look at these cases in two things. We have to look at the static factors, and of course we have to look at the dynamic factors. The dynamic factors are the existence of intervention and the like. If the people that are supervising his treatment say, you're good enough to be able to assist these individuals in working through the pathways to offending court cases or coursework, and my expert says he recognizes that, I don't know how much farther he can go. And the last thing I'll say is this. Whether or not you go from a level 2.2 phase or you go to a 3.0 phase doesn't define whether or not you have developed interventions. By all accounts, again, there's no question that my guy has identified physical interventions. So now the question becomes the nebulous concept whether or not he can identify situations and he can use what he's, how do you measure that? I mean, really, how do you measure it? And I guess, to my opinion, you measure it by his behavior at the institution. And again, over 10 years, 1 OBR, maybe 2, I can't recall, there was some confusion in my records whether or not there was 1 or there was 2, but most importantly, none of them were sexual related. So I not only look at the facts of this case, but I look at where it's going as we progress along. Admittedly, my guy's record is, I mean, we all know how bad it is. We all know how bad the diagnoses are. But it's 32 years. And over 32 years, if I understand the test correctly, under Hill, it is whether or not the impairment, mental abnormality, or personality disorder persists. And I submit that when you look at the evidence that's here, it does not persist because he's developed the interventions that are necessary. And most importantly, he's 62 years old, he's had health problems, and he's been doing every piece of treatment that's available to him. So at what point does he get to be done?
Now, you make a very compelling argument, but what do we do with the fact that it's a jury verdict?
I think that the case should have never went to the jury. I think it's the kind of case, much the same as my brother and I were talking before, where the case I'm writing and finishing this afternoon, the jury came back and said, can we speak to the treatment provider? That didn't happen in this case. But what I think should have happened is that it should have happened in the judge's mind, in that he's done everything maybe that he has to. And maybe, based upon the evidence, I should make a determination based upon what I see, rather than saying, okay, there's enough. Beyond a reasonable doubt is a considerable standard. And to say all the evidence, when it's taken in the light most favorable to the Commonwealth, is that convincing? I don't know that it was here. I just don't think, I think the case should have been kept from the jury, and the judge should have pulled the trigger and said, you know, sometimes it just doesn't get there. And this was that case, simply because of all the things that I've stated before. Again, and I'll finish with this. When do you find a guy with a static 1 that's been in treatment for 14 years and became a peer aide and is doing everything possibly that he can out there? You find me another one, because I don't have any in the stack of files that I have in my office. I have nothing further.
I see no questions. Thank you very much.
Thank you.
We will hear next from Attorney Mansfield.
Good morning. May it please the court, Brian Mansfield for the Commonwealth. This case, the sole issue is whether there was sufficient evidence to support the jury verdict that the petitioner remains sexually dangerous. And the evidence is reviewed in the light most favorable to the Commonwealth. The Commonwealth strongly supported each of the elements of sexually dangerous with strong evidence. In fact, the first element, that the petitioner had been previously adjudicated a sexually dangerous person, was not contested. The second element is whether he had committed repetitive and compulsive sexual acts of misconduct. He was convicted twice for an offense against a 5-year-old boy and his 3-year-old stepdaughter. But more importantly, he admitted, at the current time, he admits to having at least a total of 61 victims. At other times, he's admitted to having 150 victims, about 50 of them which were when he was an adolescent, and 100 of them as an adult. So clearly he...
Including people he approached or intended to have as victims, but where nothing happened.
Correct. Yeah, some of those he had the intent, but was unable to commit the crime. I note that he puts himself in a situation to have access to victims. He drove a school bus or a car to drive children, and most of them vulnerable children, to school. He joined the Boy Scouts as a volunteer. He was married, but he says he was not attracted to his wife. He just considered her a baby factory to gain access to more victims. The petitioner suffers from 3 mental conditions: pedophilia, sexual sadism, and antisocial personality disorder. With pedophilia and sexual sadism disorder, they don't remit on their own. They're persistent and chronic conditions. There is no cure for these conditions. One only learns how to manage them through treatment. And in this case, it was the opinion of both of the qualified examiners, who are highly qualified, and the representative of the Community Access Board, that the petitioner had not sufficiently learned the tools to manage these 2 paraphilias, again, pedophilia and sexual sadism. He also suffers from antisocial personality disorder. And as the evidence showed, the combination of deviant sexual arousal or having a paraphilia and antisocial personality disorder are 2 of the most robust risk factors for sexual offense recidivism. When we start to look at the Boucher factors for likely, the combination of pedophilia and sexual sadism, as far as the severity of the anticipated harm, is extremely high when the same individual has both of those. Again, the static 99 score was low, and as was predicted, it does not take into consideration any of the dynamic risk factors. It does not take into consideration the 3 mental conditions that the qualified examiners and the CAB representative identified and diagnosed the petitioner with. And it doesn't take into consideration any of the dynamic risk factors, and even the extent of his offending, because the static 99 only looks at offenses that led to a conviction.
I thought that the number of offenses, there's some hint of this at the trial, that the number of victims wouldn't change the static 99 unless they were in different categories or something? Is that right?
For prior offenses in the static 99, you have to commit an offense and be caught.
But, yeah, I understand that, but I'm saying if he had been caught in these other myriad cases, would it alter the static 99 score if all of them were still within the same category of victim?
If all the victims, there were three factors on the static 99 that deal with victim choice. One is stranger victims, one is unrelated victims, and the third is male victims. So those wouldn't have changed if they, but again, it's the sheer.
But I'm not saying that it doesn't matter. It matters a huge amount, obviously, what we're talking about here, the difference between, well, the course of conduct here. But I'm just asking if the static 99, if he'd been convicted of 7 crimes, wouldn't the number still be 1?
No, the victim, because one of the factors is prior sex offenses.
Number of prior.
Number of prior.
And that increases the static 99, and he's not already at the top.
That's correct,
I see,
because
okay,
you
okay,
don't
okay.
look at the most recent offense. You only look at offenses prior to that, and where we only had 2 convictions.
Yeah, I see.
You
I see,
just
okay,
had the one,
okay.
so that could go up. And he had already lost 3 points on the static 99R because of his current age. So the static 99 instructs not to consider age. If you're using the static 99R, do not consider it again. It's fully accounted for under the static 99R. And again, he has these, it all comes down to the conditions and the severity and the strength of those conditions, and that's what the experts, in reviewing his treatment records, found that he had not discussed fully the multiple parts of the offending. He hadn't developed interventions, and he was unable to really talk about it in the interviews. So, in that, for those reasons, the third element that I didn't mention was likely to reoffend. He was clearly, in the opinion of all 3 of the Commonwealth experts, likely to reoffend sexually. So if there are no questions, I will rest on the Commonwealth's brief.
I see none. Thank you very much. Excellent arguments by both of you. Very helpful to us. We're gonna take our traditional mid-morning break and return in 10 to 15 minutes to hear the remaining 3 cases.
All rise, please.
want me to?
Testing, 1, 2, 3. Testing, 1, 2, 3. Testing.
Do you want me to put it up a little?
One, two, three. Testing mics. All set. Thank you. Testing, 1, 2, 3. Any item? Okay.
I put it back to where it was. I did turn up the walls.
Mic test, 1, 2, 3. Mic test, 1, 2, 3.
I don't know what testing.
Testing 1 2. Testing 1 2. Testing. Testing. Testing.
Now I'm on channel 1, sorry.
Recorded another test.
Testing.
Try it again.
Testing. Testing. 1, 2, 3.
Got it.
Testing 1 2. Testing 1 2. Testing. Testing 1 2. Nothing.
It's not working.
Closing session, please be seated.
Hello, welcome back. We turn next, we're going to do these cases, as I understand it, out of order. And therefore, we will be hearing first the case that was originally fifth on the list. It is number 2463, KIVI versus KIVI. It is partially impounded, so I trust that counsel will adhere to the impoundment order. And we will hear first from you, Attorney Drew.
Thank you, Your Honors. Good morning, and I represent CYNTHIA KIVI. This case has many hallmarks of being an abusive relationship. To start, let me address the contempt that is on appeal. The reason for the contempt was failure for Mr. Kibby to timely pay alimony. And at the time the contempt was heard, his order was $172 a week. By the time the contempt was heard, he was 14 weeks in arrears, over $2,000. That is significant funds for my client who is of limited means. But financial control is part of the abusive dynamics. And what we have from Mr. Kivy is a failure to alert his wife that payments would not be made. He claimed that he was without income for 5 weeks because it took him that long to claim unemployment, but the arrearage was actually 14 weeks. So he made no effort to pay anything towards his arrearage between the time he started receiving unemployment and he appeared in court in April of 2022 for hearing. And the case was consolidated with the underlying divorce trial where Mr. Kivy stated that he was unable to get to the bank on time. But the stipulation signed by the parties as to payment was until his bank account started making direct transfers to my client's bank account, he was to send a check to Mrs. Kivy.
There was a hearing, correct, in April 2022
Yes.
on the contempt? We don't have that transcript, right?
Correct.
So how do we know what was consolidated for trial? Because when I read the judge's decision, it read as though the past arrears issue was resolved in April 2022 at the hearing, and what was remaining at the trial was whether there was any current arrearage.
The stipulation that was entered into was marked as temporary, and at the hearing, at the beginning, at the end of our settlement negotiations for the amount that was owed and how it would be paid, the court consolidated what was left of the cases to be heard.
What was left? What was consolidated? That's what I'm not understanding from the record.
There is an order where the judge said that the contempt hearing would be consolidated with the divorce for trial.
Right, I understand, but at that point, the past arrearage was resolved.
Pardon me?
The past arrearage was resolved by stipulation, so what was moved forward to trial?
The attorney's fees and any amounts that were due as of the date of trial. So that my client testified that Mr. Kivy was 4 weeks in arrears at the time of trial. Mr. Kivy denied that.
And the judge found he was not?
Found that he was not in civil contempt, correct.
The judge found he was not, didn't have any current arrearage. So what would be a basis for fees?
There's no specific finding, but he does not credit my client's testimony as to the arrearage. As noted on the docket, my client did have to file a complaint for contempt on non-payment of alimony a few months later. And also, what my client is asking for the court is for the court, and it was stated again at the beginning of the trial, was that the contempt and the attorney's fees were yet to be heard by the court. And as part of his judgment, the court denied any attorney's fees in favor of my client. So we believe Mr. Kibby had ample notice as to what was being tried on that day, and would ask the court to to remand the contempt for an entry of guilty and a hearing on attorney's fees. As to the alimony, this is the linchpin of the divorce case. The parties settled the property division, but alimony remained contested, and that, along with the contempt, is what was tried at the time of the divorce trial. My client testified to many instances of domestic violence, not only towards
There's
her,
no
but to
sign
the
that
children.
that the domestic violence that she testified to has anything to do with the alimony decision, right? You're making an inference that the judge, disbelieving her allegations, therefore also took other steps that you also think were erroneous, but there's no actual indication of that, right?
Well, there is no statement as to that. There's no finding as to that.
No statement that, I'm sorry, that what?
There is no finding that.
That links them in any way. I'm just trying to figure out, I don't see that abuse was the emphasis below, but it does seem to be here. And I'm trying to figure out how that abuse affects, we have the alimony before us. I'm not saying it doesn't affect it. I'm just trying to figure out how you say it was affected by the abuse or abuse allegations.
Well, it seems that the abuse was dismissed, and all of my client's statements as to abuse was dismissed. Abuse does come into play under the statute on both property division and alimony.
How does it come in alimony?
It's related to alimony if there was significant damages to the survivor in terms of ability to work or other behavior that
And what is the evidence of that you put in below?
We do not have an expert testify, Your Honor. My client was indigent, but the testimony was that she was depressed 5 years into the marriage. She had ongoing psychiatric help. She had ongoing physical issues. Even if the abuse is set aside, between my client's mental health concerns as well as physical limitations, the court, our argument is that the court imputing income to her as if she could work part-time was not appropriate. That the client's testimony was credible as to her limitations, and yet Mr. Kivi's testimony that he had aches and pains as a result of his work was credited.
Well, we weren't there to see the witnesses.
Pardon me?
We weren't there to see these two witnesses.
You were not, Your Honor.
So it's very difficult for us to judge whether one was credible and the other not, or whether that's wrong. I don't know how we're supposed to review that.
There is a finding, Your Honor, that is inconsistent with my client's ability to work, and that is her being accepted for Massachusetts, the equivalent of SSI in Massachusetts. And she received expanded health care benefits.
Does she have to be totally disabled to get that?
She needs, I do not have that information. I know that she...
Because he only said that she could do part-time work.
Yes, I understand, Your Honor, which seems inconsistent without evidence that she was able to work part-time when she started receiving Mass SSI. That's what it's called. So our argument is, Your Honor, that she's now 62 years old. She always had jobs that were for unskilled labor. She worked hard during the marriage. She testified that she needed to take 5 years off during the marriage for her depression. And she testified to her anxiety attack that she had on her last day of work, and that during that testimony, she also testified that she was able to get through the panic attack because of her treatment with her therapist. So setting disability aside in terms of expert testimony, the client did testify to multiple conditions that she has. And it was not denied that my client had several surgeries during the pendency of the divorce.
Now, she was given alimony in an amount that was 28% of the difference between her imputed income and the income of the income credited by the judge of the husband, right?
Yes.
If it had been 2% higher, and I don't know where 28% comes from, and I'll see if I can find out in the second half of our argument. If it had been 2% higher, 30%, it would be essentially untouchable by us, right? Under the Alimony Reform Act?
Yes, there is the issue of imputed income, but yes, from the statutory percentage that was used, 30 to 35%. And that's saying once the client shows that the current alimony or an alimony award, which she was getting $172 a week, was inadequate to meet her needs, then yes, the judge certainly had discretion between 30 and 35%, and would have discretion otherwise to be lower with the list of factors that accompanies the statute. But Mr. Kibby did not meet any of those criteria.
Did the judge make a finding of what her need was weekly?
Her needs, Your Honor, her needs do not include what she had during the marriage. What she really was looking for and hopes for is an ability to live on her own, to live independently.
But if that costs more than 30% of the difference between the proper incomes of each of them, the judge can't award more than 35%, it looks to me like. It says ordinarily or something, but...
Yes, without extraordinary circumstances.
Yeah.
And Mrs. Kivy did testify that she knows she may have to use part of the annuity to meet her needs, which she would like to do, but she'd like to minimize that because she recognizes as her health deteriorates further.
I agree with the common sense of that, but we do have this legislative language now, not so new anymore, I think it's 10 years
Yes.
old already, that talks about 30 to 35%
Yes.
being the maximum, which is a foolish way to write a sentence, 32, 35%, but it seems like it puts 30% in essentially a safe harbor.
Yes, Your Honor, we agree with that. The position of my client is that every single dollar she can have in alimony reduces her need to withdraw from the annuity, which she, as was stated, should like to preserve because at some point she anticipates being totally disabled and needing assisted living. So
The judge stated before the trial started, trial, that he probably was not going to set alimony at 30% and would be based on need. Is your argument is that's error as a matter of law or as a matter of fact?
as a matter of fact, Your Honor.
Matter of fact, okay.
Well, and law. The 28% would not, once Mrs. Kivy's needs were not fully met, which they were not even under her earlier financial statements, the court then would shift to the 30 to 35% formula. The 28% would justify reductions, but none of the factors listed in the statute applied to Mr. Kibby, including tax consequences, because there was no evidence of tax
What about
consequences.
oh no, please.
That seems like you're saying it was a error of fact. You're not suggesting that the judge could not issue an award less than 30% of the difference, right? As a matter of law, that the statute allows him.
Matter of law, no.
Okay.
But wouldn't we need to know what her need was? I didn't see a finding by the judge of the exact dollar amount of the need. Then it can be below 30%, but it has to be either need or this 30 to 35%. And I guess what my question is the 28% number based on need?
Not according to my client's testimony and financial statements, Your Honor.
Was there a finding by the judge that contradicts those findings? I mean, that testimony?
There was a testimony which was accepted from both parties that just to find independent housing alone for each of them would cost about $2,400 a month in the area where they live. And that would put them in the same position they were during the marriage. There is no evidence that Mrs.
Did the judge find that they could find monthly housing at less than that? For example, I think your client was in some kind of religious organization's housing or something?
She was in Father Bill's, which is for homeless people without homes. And however, that was, she was grateful for the accommodations. However, there was lack of privacy, and what she had was a bedroom
I see.
To herself. So for both of these parties, if they want to be restored to independent living as they were during the marriage, additional income would be needed. Now, my client did testify that she had applied for lower cost housing, subsidized housing, and town housing, but that she had not received any positive news yet, and it took often 8 years to...
The judge didn't credit that.
Pardon me?
The judge didn't credit the 8 years part.
Not credit it, no, without any evidence either way. Simply did not credit it. So, Your Honor, what we're looking for is for the case to be remanded and have alimony entered at between the 30 and 35% without the 2% reduction, and also whether the court can determine whether that's as date of hearing or through what the judge at one point used was averaging income.
Okay, your time has expired, and I see no further questions, so thank you very much. And we will hear now from Attorney Fernley.
Good morning, Your Honors. If it please the court, Attorney Jennifer Fernley for Kevin Kibby, the appellee. Just a clarifying comment. The court asked my sister at the bar about a hearing in April of 2022. There was no evidentiary hearing. There was the entrance of a stipulation of a temporary order on a complaint for contempt and merely the approval of that stipulation. So there was no testimony other than approving that stipulation.
So what was moved forward to trial?
The issues at trial, as Attorney Drew stated, were the amount of alimony. There was no dispute as to the duration.
On the contempt?
Merely the issue of whether my client would be found in contempt and the attorney's fees.
Found in contempt for that initial period, the 2408 or whatever it was that had not been
That
paid.
is correct, Your Honor. There was no subsequent complaint for contempt after that. And so I will start with the complaint for contempt. In order to find someone in contempt, the lower court judge needed to find clear and convincing evidence that there was a clear and unequivocal order of the court. We absolutely stipulate to that. There certainly was. Equally clear and undoubted disobedience.
He didn't pay. He didn't get to the bank on time.
His testimony was that he couldn't.
I don't know what that means. He has a clear and unequivocal command from a court. I guess he could move to modify, but without it modified, doesn't he have to get to the bank on time?
No, Your Honor, there is a specific carve-out for inability, and his testimony was that two things happened. First, that he was delayed in receiving any unemployment benefits, and second, that because he was working, he couldn't get to the bank on time. That was his sworn testimony at trial, and the judge credited it. And there was no...
I thought the judge said that because he couldn't get to the bank, but he had offered Venmo and she had turned it down.
He did say that.
Okay, so, but Venmo wasn't part of the, I get what he's saying from a practical standpoint. Is he allowed to not find someone in contempt because they offered an alternative to the clear and unequivocal command?
Yes, Your Honor, I believe that he is. He's allowed to weigh the credibility. I would also say to...
Wait.
I'm sorry.
There's no credibility question here. He doesn't comply with the order. You say it's necessity. I didn't see the judge saying that. He doesn't comply with the order, but he offers an alternative. Does a judge have discretion not to grant a contempt if it is nonetheless an unequivocal violation of a clear command?
Yes, he does.
Do you have a case for that?
I do not. However, it is the totality of the circumstances that allows a judge to assess whether or not there's an inability or whether there is a clear and undoubted disobedience based on that inability. And we have to recall that it is Mrs. Kivi's burden to carry. It is not, this is not a child support case.
But he admitted he didn't go to the bank on time.
Yes, he said he was unable to. That was his sworn testimony, that he was unable to. And there was also one line of testimony in the transcript where he was asked, what was your bank account balance? And his response was probably zero.
So you said it was her burden.
It is her burden.
Correct me if I'm wrong. My understanding is that inability to pay is the defendant's burden in probate and family court matters.
Well, that is his defense, but it is her burden to prove that there was a clear and undoubted
Right,
disobedience.
I understand that, but where it's based on inability to pay, I thought it was his burden.
That it's his burden to prove the defense. That's correct.
Okay, in your brief, you said it was her burden to prove he was able to pay.
I do believe that that is part of her burden to prove, and she did not do that. She raised during the testimony.
I'm sorry, so is it her burden to prove he's able to pay, or is it his burden to prove he's unable to pay?
It was his burden to prove that he was unable to meet the order, not able, I'm not arguing with your honors, and not that he was able to pay, because he did not allege, well, except for the time that he was on unemployment, that he didn't have the money. He alleged both that there was a delay in his unemployment benefits reaching him, and then that he couldn't get to the bank. That was his allegation. And there was no testimony other than him talking about that he had nothing in his bank account. Other than that, there was the stipulation. Let me turn to the spousal support, which, as I understand it, the dispute here is the amount of spousal support. As your honors pointed out, the statute does not require that the spousal support be between 30 and 35%. That is the range that they would not expect it to be above. And as I look at the judge's findings, if I look at finding 83, I see that Judge Stanton established the wife's needs at about $707 a week. And if you look at what he imputed income to her, which is $300 and change, and then what he increased my client's spousal support to, which was $315, you almost get to that 707 number. So what
Wait,
Judge Stanton...
where's this 707 number?
Finding 83, Your Honor, in this would be page 16 of the Record Appendix, Volume 4.
Wait a sec. They have been called something else here for some reason, so I have to... Volume 2, hold on. Do you know what this document is called in?
What? It's
Oh, yes,
in
I
the-
see. It's just called appendix here. All right, so page 16. And where does it say 707? I'm not seeing that.
Is that 70794? Is that the?
That's correct.
So is this the?
Well, wait, I see at the top. Okay.
So it doesn't get you to 707, right?
It may get you short of 707.
Yeah.
However, there was a question from the panel about the establishment of the wife's needs to my sister at the bar, and Judge Stanton does establish what her needs are.
No, that's her current weekly expenses, but she's doesn't have a home.
At that time, she had stable housing. She wasn't in a shelter.
And she stay there for the rest of her life, or?
The testimony at trial was that it would have been, it was going to be reevaluated in July of 2023. That was her testimony at trial, that she did not know whether her housing would end or whether or not she'd be allowed to extend. With regard
Is it permissible for a judge to find that someone who used to live in a house has no needs for housing above what a charitable organization will give to her because she's homeless?
I think it's permissible for a judge to find that at the time of the divorce, her needs were what they were. I don't think that a judge can extrapolate what might be needed for housing in the future. However, the judge did comment on that both parties were going to need to establish housing, and he tried to balance that. I think he made a specific comment about my client not being able to live with his mother for an extended
So
period.
where does the 28% come from? I still don't understand that.
The 28% of the difference between...
Yeah, where does the number come from? In the evidence, why did he, or he, I guess, choose that number?
Judge Stanton does not specifically say why he chose that number. Many probate and family court judges, because of the change in the tax treatment of spousal support, had been going below that 30%.
Yeah, the statute doesn't let them do that, though.
I understand that. It remains as it is.
That would be an error.
Yes, I understand. I believe that the 28% it meets Ms. Kivi's needs as best the judge was able to do it, while preserving my client's ability to pay and meet his own needs. That's the balance.
Well, shouldn't the judge have said, although this is only 28%, it meets her needs, which are X dollars per month?
I think the judge's analysis of all the other factors in the divorce very clearly establishes why he did what he did. He went through each of those analyses as to their ability to earn, as to their capacity, as to whether or not, for example, my client would be able to continue to work. And it's very clear that my client was continuing to work. I know that my sister counsel made a comment about how the judge accepted my client's testimony that he had aches and pains. That's true, but he continued to work a full-time job as
Well, that's not the point. He found that she could work part-time.
That's correct.
He said that she could earn $315.50 a week.
Correct.
Then, for some reason, he also gave her $315 a week in alimony. But you don't just give someone what they can make and give them double that. I mean, I don't see where the $315 came from. That's all I'm saying.
I understand, Your Honor.
And it adds up to, what, $630, and you've just said that her needs are $700. So shouldn't he have at least gotten to 30%?
No, Your Honor, because I think getting to 30% would have consigned Mr. Kibby to a complete inability to live independently. And again, the alimony...
What's his annual income?
His alimony income was between $70,000 and $80,000 per year.
And what does $300 a week come out to in alimony? 315?
I'm sorry, Your Honor, I didn't...
15 grand, something like that? Okay,
Yes.
a little more than 15. So she's going to wind up, if she worked, she says she can't, but the judge found she could. If she worked, she's going to come out to about $30,000 altogether.
That's correct.
So he's going to have about $65,000.
He's going to have $65,000 before tax dollars. So he is going to pay the taxes on all of the funds.
I agree with that.
And so that gets him, I would suggest to Your Honors.
Doesn't she have to pay tax on the $15,000 she supposedly can earn?
She would if she
Yes.
earned it.
Yes, well, but the presumption is that she's going to earn it.
Well, she would be presumptively paying at a considerably lower rate.
Did you put all these tax numbers before the judge?
No, there was no tax numbers established before the judge, Your Honor. Judge, continuing on, the issue of Ms. Kivi's alleged disability. Ms. Kibby alleges that she wasn't permitted to put an expert before the court. To be very clear, this case was litigated over the course of 2 years, and in September of 2022, we had a final pretrial conference, after which a trial order issued, closing discovery on January 20th, 2023. That was maybe 45 days before trial. After that, fully 30 days before that, that was when Mrs. Kivy sought an expert. She had never sought an expert prior to that time. She did not disclose an expert on any pretrial memo. She had not disclosed an expert on any of her discovery. And so it was not error for Judge Stanton to enforce his trial order to decline to give her funds for an expert.
Do you know why your client objected to the disbursement of these funds in equal halves from the escrowed amount?
Yes, I do. He objected to the disbursement because we did not want to delay the trial. And the disbursement of those funds, had they been utilized to have an expert, would have resulted in a delay of the trial.
So it wasn't that he was claiming that he owned her half of those funds. He was just saying he didn't want to give her the money so she couldn't hire an expert to litigate her case.
He never made the claim that there should have been a disproportionate division of those assets. Okay. Never, not once. He did not ever claim that he should have received more. It was always going to be a 50-50 division.
This was in the opposition to her motion for funds, presumably?
Yes.
Okay.
The issue for that was merely that there should be no further delay, having been in the family court for 2 years and having been assigned a trial date fully 6 months previously, and having waited for this trial date, we didn't want any further delay. So he never made any further claims. If there are no further questions, I'll rest on my brief.
Your time has expired, so thank you very much. Thank you both. Very helpful arguments for us. Let's mute the microphone for a second. In here.
Great.
Okay. Since the mute button doesn't seem to do anything, I don't know if I'm on or off. Is my mic on? Can you tell? Yes. Okay. I thought that button turned off because it says mute. All right, we are going to hear. I gather all technical issues have been resolved with respect to the fourth case, which is Department of Children and Families versus Father. This is number 2024-0137, and assuming all of our counsel are here, we will hear that next. I gather the appellees are splitting their time, with the department taking 9 minutes and the Children's Council taking 6 minutes. Is that correct? Yes. Okay. This is an impounded case, so of course don't use the names of people, older child, younger child, mother, father, or child 1, child 2, however you prefer. And we will hear first from Attorney DeFeo.
Good day, Your Honor. Oops. Wow. Sorry about that. Let's see if I can get a little less static.
Oh, it's probably feeding back from your mic.
Okay. Can you hear me, Your Honor?
Yes.
Okay, thank you. Again, Your Honor, Jennifer DeFeo. I represent the appellant Father. Father is asking that this court vacate the termination decree and remand this to demonstrate his current fitness. When the juvenile court judge heard this,
No, that's me. I think I just did that.
too much feedback.
Let's try
One moment,
try it again.
I will do it with my hearing aids. If everyone can speak loudly, that would be.
Well, I mean, I want to make sure that you can really hear everything. So if I would try our assistive device again, and we'll see if we can get it to not feedback. I think. I just want to make sure that that you can actually hear. Can you hear us?
I can hear you, but what's happening is I'm hearing an echo of my own voice.
Oh, I see.
Can you hear me now?
Yes.
I could probably do it this way. It
Although
is
we
still
have
a
to
little bit-
record her for the record.
Right, and I'm actually hearing directly through FTR.
I don't know what FTR is.
For the record.
Oh, I see. Oh, you're hearing it from,
Exactly.
okay.
I think we can do it. I think.
Okay, I'm game to try, but obviously I want to ensure that your client's rights are protected, so.
I will let the court know if for some reason the echo is significant enough that I cannot do so. So again, Your Honors, what we are seeking today is that the termination be vacated. The juvenile court justice was required to look at father's fitness, not at the time of removal, but in 2022 when the trial occurred. And the man who stood before that judge in 2022 was not the same man who stood before the court in 2018 on the removal petition. The judge herself did acknowledge that he made substantial progress. She stated that she was encouraged by his continued engagement in the medical assisted treatment where he was receiving his Suboxone, individual therapy, his long-term employment, and the completion of the inpatient and parental programs. He also completed a batterers program, which DCF found satisfactory enough that they removed any type of abuse classes from his family action plan. And that's a very substantial telling that they felt as though the domestic violence aspect had been resolved. The parenting evaluator found that this was a man who lovingly and genuinely cared for his children, and that the data indicated he was concerned and able to address his children's emotional needs. This was in 2021, shortly before the trial. Father has, without a doubt, a long criminal record. But what this court needs to focus on is not his past, but the fact that 5 years prior to trial, he did not have a single arrest, not a single incident for anything, not even a traffic ticket. Under 101, 5 years renders that stale.
It seems to me that the critical point the judge keeps coming back to, and the judge, can you hear me?
Yes.
Okay, and the judge comes back to several points repeatedly throughout this very detailed decision. The judge keeps coming back to untreated bipolar disorder. And you say at some point in your brief, you say there was not adequate evidence of that or something, or there's clear error. I don't understand that. It seems like he has a diagnosis at least of bipolar disorder. I appreciate that he thinks, as you told us repeatedly, that the medication is killing him, but it isn't. It's treating his bipolar disorder. And without it, why isn't it a reasonable inference that his scattered and tangential speech, and presumably the thoughts behind it, that his distraction when he's with the kids and one of them is running toward the street and he doesn't notice it, that even his ability at a visit to monitor both of them at once is related to that?
The question is, even if he has bipolar, when does it rise to the level that he cannot meet the children's needs as the children's needs are at that time?
Well, but we have evidence at that time. Again, these are little tidbits. But there's evidence that he got overwhelmed. Maybe it's just one visit. I mean, there's lots of things to be said about it, but that he got overwhelmed with having both of them at one visit to the point of not being able to respond appropriately to one of them needing to go to the bathroom, and that while on the street, both of them were sort of out of his immediate control. Maybe one, I don't remember, one running toward the street and one near the street, something like that. Why isn't that evidence of exactly that, that he's not able currently to care for both of them?
First, Your Honor, it goes with the timing of when those happen. And second of all, the reality is parents get distracted. And if it were a parent who wasn't under the guidance of DCF, whose child ran towards the street, they are not going to have their child taken away or found unfit. The child...
No, the child might get run over.
But he didn't. So you're asking that a speculative thing that didn't happen be used to show that he is unfit. It has to be predictive of an ongoing...
Doesn't he deny that he is a perpetrator of domestic violence?
He does not, Your Honor.
I think he says he was provoked.
Yes. So with this man's thinking, he doesn't have the same concept of things that other people may have. When you ask him a question, what did you learn? He's going to answer that, but it may not be what you or I or the questioning attorney meant by what did you learn. The perfect example of that is, what did you learn in your parenting class? He learned all these things about the other men who were in the class. Nobody said to him, well, what did you learn in that class as it applied to your own children or your own life? That wasn't the question. The things that are really important is this man was...
Why didn't his counsel then ask that question?
I cannot speak for his...
I mean, I assume that he was called as a witness by his own counsel, right? Or
He was, and
okay.
he was also prosecuted. I cannot speak to trial attorney.
Well, but you have to speak to what's in the evidence.
Exactly. But the evidence shows he answered the question he was asked, which was, what did you learn? He said, I learned about the men in the class who are going to succeed, who are clearly drug users. He answered the question.
How can he be fit if he has no stable housing, if he's living in a storage unit and or a Salvation Army store or place, whatever it is, I don't know if it's a shelter, and if, when asked what he intends to do with the two children if they're given to him, because if he's fit, they should be handed to him, he says he's sure his sister will let them all live there, although he hasn't asked her. How can a person be fit with no housing?
So, Your Honor, DCF, in and of itself, said, quote unquote, housing is not an impediment.
I don't care. The judge said he has unstable housing and doesn't have a realistic plan for what to do with the children.
He did have a realistic plan. He was on Section 8 waiting list. He also said, I can speak to my sister.
He didn't grant a waiver so they could look to see where he was on this waiting list, or even if he was, right?
He signed dozens.
I didn't ask you that. I said he didn't sign a waiver for that.
I am not aware on the record as to why he did or didn't. And yes, he did not do so for that particular thing. But the times that he was involved with getting housing, he was disqualified once, which DCF acknowledged was not through his own fault. Back before he was able to achieve sobriety, therapy, treatment, all of these things, yes, he had an issue in housing. But at the time of the trial, it is well known that it's a parent who does not have children in their custody is going to struggle to get housing. Reunification helps do that. It doesn't happen overnight, but there are shelters he could go into with the children. There is no shelter that's going to take a single white male into a shelter for families who doesn't have his children with him.
What's his race got to do with the shelters?
It has to do with the fact that he has nowhere to go, and that had he been in a different category, we don't know. There are specific shelters that are designed for specific genders.
Genders, of course. For specific races, we have shelters that...
So Casa Mana deals with, as far as I know, there are no non-Hispanics in that program from when I last dealt with them.
Because they don't accept them?
It's not that they don't accept them, but that is not who is encouraged to apply.
Okay.
So with that being said, he does have the ability to get housing upon reunification. And the thing that also has to be noted is that DCF made one referral for him, one, and that was in 2019. So it's not as though they felt as though this was an impediment, and they acknowledged it was not an impediment.
I think that testimony was talking about a 6-month period of time in 2020 when he was living in Medford, I think with a friend, right? How could they say it's not a barrier to reunification when at the time of trial he is living in a storage facility?
Because once reunification was in the process, he would have abilities to be able to get into programs that he cannot get into without his children in his care.
Okay, but the testimony you cite about it not being a barrier to reunification, isn't that talking about a very specific time period in 2020?
That's not how I recall it, but that is possible. So I think that that is one very small factor then. I think what needs to be focused on is the fact that this man was working 40+ hours a week in a highly stressful job and was not having any issues. We were talking about provocation, that he didn't consider it domestic abuse but being provoked. He acknowledged what he did in a situation where he was arrested while being with mother. He's ended that toxic relationship. He took the classes. DCF took the domestic violence.
But the question is whether he gained insight into the domestic violence issue. And the fact that he admits the fact but doesn't characterize it as domestic violence strikes me as maybe not, or at least supporting the judge's conclusion that he lacked insight.
States that issues arise when one person is provoked or provokes another person, and it escalates and the police get involved. So again, this is a man who talks what he feels. Just as a trial attorney objects constantly, non-responsive. He may not have been perfectly responsive, but he could be redirected. And when he was redirected, he never got upset. He never had an outburst. He was able to control his anger. So maybe he doesn't have the label that the judge would have liked or that we would typically see domestic violence, abuse. He says, yes, this happened. I got angry. I was provoked. What caused it? Lots of things. Lack of sleep, drug use. I no longer drink alcohol. These are things that he felt influenced him to become an angry person. And that was behind him. He was able to get his life stable with the exception of the housing, which again, that is a small piece in this big picture. Because once reunification happens, he will have the ability to have appropriate housing. And as I do see my time is winding down, I would like to very briefly talk about the special needs of the children. And I do think it's important to note that the parenting evaluator found that father could indeed meet the needs of the children where they were at that time. And this was from 2021. While there was some speculation that he may struggle to be able to rapidly pick up on their changes, he says, I have support. I have my church, I have my people in the Salvation Army, they all have their special titles. I have the people that I can go to and say, I need help. And that is critical for someone in his position. DCF likes to see that because that's what they ask. Who are your supports? He had a whole bunch of people who were there to help him every step of the way. So, Your Honors, if you do not have any other questions, I will rest on my brief.
I think that we do not. So thank you very much. Excellent argument. We will hear next from Attorney Gallup.
Good afternoon. May it please.
Yeah, you should.
May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the decrees of the lower court because the judge properly found father unfit to parent the children based on his long-term substance abuse, his housing and financial instability, his mental health concerns, his perpetration of several known acts of domestic violence while the children were present or nearby, and his failure to take responsibility for the reasons that the children came into care when he neglected to tell the department that mother had in fact relapsed and that she was using substances or in the children's presence. Now, the court did acknowledge that father did complete several services throughout the life of the case, but the issue is that at the time of trial, there were still various deficits that he had not addressed, or he had addressed inconsistency, or that he minimized or dismissed altogether. Now, none of the findings are clearly erroneous, and I think that my sister is essentially presenting all of the information to you and asking you to review it de novo and come to the same conclusion, and that is not this court's obligation with regard to child welfare appeals. With regard to, my sister focused on the housing, and there were several findings that the judge made that where father testified that he lost unsupervised, or in one instance he lost unsupervised visits because he was in the shelter at the time, he was on the top bunk and not getting sleep. And the court credited this testimony as evidence of his lack of insight into his mental health issues, and instead of identifying that the reason that he lost unsupervised visits was because he was not paying attention to the children. And on 2 occasions, one of them was going to run into the street, and on another occasion, they were going to cross the street without him, or he crossed the street and left them at the other side. His mental health prevented him from identifying his deficits, and that it was untreated, and thus, sorry, I'm like losing my train of thought. That like the fact that he identified the circumstances as not being his actions, and rather what was going on where he was at the time, demonstrated that he didn't understand how his mental health impacted his ability to safely oversee the children and care for them.
Are the children still in the placement they were in at the time of or about to be put in at the time of the approval of the placement decision?
So the findings identified that a pre-adoptive home had been
Yes, I'm asking you actually something outside the record, which is, are they still there?
Yes, so to answer that question, I would have to go outside the record, and it is my understanding that they are still in that pre-adoptive home.
Okay.
I don't know if my brother might be able to speak.
Well, I'm going to ask him a bunch of questions.
Sure. Father, with regard to domestic violence, he testified that it was provoked anger, and so despite having completed an anger, I think a batterer's intervention or anger management, the fact that he was unable to retain any information from those courses suggested to the judge that the children would be at risk if they were to be returned to his custody, for he had not developed insight into that behavior. I think that with regard to the untreated mental health. Now, my sister argues that there were conclusions of law that father needed to be on psychiatric medication, and as I read the findings and conclusions of law, it was that there was an alleviation of father's mental health symptoms when he was on medication, but that the judge did not, in fact, find, obviously because the judge is not a physician, that he needs to be on medication. But the fact that all of father's providers were consistently saying to him, this would be helpful for you, and instead of, even trying that out, he declined that.
Well, he had been on those medications before, though, right? He had been treated for bipolar disorder. He stopped in 2019, I think. Is that wrong? He decided to be weaned off of everything he was
Yeah,
on.
I believe the record, from the record, the last time he was on psychiatric medication was in 2019. I think like August was the last evidence that he was taking medication for that. And the untreated mental health then impacted his ability to actually obtain housing, because at one point he was offered a housing program, but because he was not engaged in, or he was not productively, I guess, engaged in mental health services, he did in fact lose that opportunity. And while he was continuing to work at the time of trial, I believe he was working, maybe 20 hours for which he was actually not being paid. So, and he was not making any efforts to address how he could actually financially support these children. When they were removed, I believe he was unemployed. By the time of trial, he was working more than he was actually being paid for and not taking, and there was evidence that he had an opportunity for a better paying position that he did not follow through on.
What about the argument about the nexus between the mental health issues and unfitness, and the as your sister had indicated that, well, if he had adequate mental health care, the unfitness was only temporary. That once that care is in place, that he's going to be on his way. What do you say to that?
I'm not recalling if it was Ms. Henderson or if it was Dr. Swaby, but there were, I think, two kind of parenting evaluations, and in one of them there was it was identified that as father's stress would go up, that his mental health symptoms would also go up. So the fact that, and the caring for two high needs children with behavioral issues, from that individual's perspective, I'm not remembering which one it was, that would be the impact on his ability to safely take care of the kids. And there was also some evidence on a related note with regard to the visit that one of the visits that Justice Rubin alludes to, where father was overwhelmed and missed several cues from the son, that he needed to use the restroom. So I don't know if I've adequately addressed your question, but if there are no other questions, the department would rest.
I have not a question so much as a message, maybe for you to take back to your client. Mm-hmm. This is the second case I've seen this year in which the department has placed children in homes where they were abused. In this case, there was violence against the children in a foster home, leading to bruising and I don't know what else. And yet, the department kept her, not only placed her there, but kept her there for 2 months after they knew of this abuse. I don't know how homes are screened. I don't know what the mechanisms are or how you wind up with abusers running foster homes. But it's a care and protection proceeding. And if the Commonwealth can't protect these children, I'm not sure what the constitutional basis is for taking them away from parents fit or unfit. So that's not before us here, but it strikes me as a serious problem. I haven't seen, of course I've seen, and we know various terrible stories, but I seem to be seeing at least twice. We've only been back for this term 3 months, so in the last 2 months I've seen another case like this. So I'm hopeful that the department can try to figure out a way to address that.
Yes.
It's not really a question for
Sure,
you,
certainly,
and it's not even brought up here, but it's a serious concern.
Absolutely.
All right, thank you very much. Excellent argument. We will hear now from Attorney, I'm going to say DeJoy, but that's wrong, isn't it?
A lot of people do call me that, Judge, but it is DeJoy.
Okay.
Your Honor, if it pleases the court, my name is Mark DeJoy. I'm here to represent an 11-year-old girl, who I'll refer to as girl, and a 10-year-old boy. They lived together in the same foster home since August 2022. You're right, Judge. The girl was at a number of locations prior to coming with her brother to this current location, and they are still there. I'll stay within the record from now on, Your Honor, if that's okay. Your Honor, I'm here on behalf of the children to ask you to affirm what the lower court has said. They would also like you to affirm the visitation orders that the judge ordered. They enjoyed the visits. The father enjoyed the visits. The visits went well. Anybody who observed the visits thought they went well. Father showed up. I don't think there were any visits missed, quite frankly, by the DCF or the father. Father showed up with snacks, appropriate games. The judge found, though, that father was leading a chaotic life, whether it be chronic homelessness, substance abuse, violence in some cases, and certainly the untreated mental health was primary on the judge's mind.
How recently have you spoken to your clients?
3 weeks ago, Your Honor.
In person?
Not in person, Your Honor, by Zoom, but I've been to the house before.
How long ago were you at the house?
Let's say 4.5 months ago, Your Honor, 5 months ago. I usually, once a quarter, Your Honor.
You represent both of the children.
I do.
At the initial placement with Ms. S., almost right away to, I guess, as part of the wishes of the younger child, but certainly to protect the younger child, the older child was removed from that home.
Correct.
Then that younger child was with Ms. S. for years, 4, I think, something like that.
That's correct, Your Honor.
My understanding is from something in the record, I think maybe it's at the time, I'm not sure when, it's like a status report or something that we have for some reason, although I think it's after, it may not be after the findings finally issue in this case. There's something that indicates during someone's visit, the younger child was missing his former foster mother, Ms. S., had regressed, was behaving like a toddler and on the floor, and was having some kind of conflict or something with the older child.
Correct.
Is it clear to you that this is the proper placement for both of them?
It is a good question, Your Honor. I've spoken to the foster father specifically on this issue on several occasions. He thinks yes, Your Honor. I do agree with him. There is an issue currently, Your Honor, that I believe the parents, the pre-adopted parents, are working on. I don't know how, it is an issue I work with, Your Honor. I don't know how you want me to, I have an answer for it. I'm just concerned.
Well, it's outside the record, but this part hasn't been appealed anyway, so.
I understand, Your Honor, but it is an issue that the parents are aware of and are working on with the collaterals. And it is almost the same issue that you point out. There is a competition, Your Honor, is the best way I could say, that is, it's been alleviated, but that's what the foster parents have reported to me.
Do you think they should have separate counsel?
I do not think so, Your Honor.
Mm-hmm.
I do not think so. You're giving me pause. You're giving me pause, and my conversations with them, don't lead me to believe that, Your Honor. At least as far as their wishes. My observations. I do take what you're saying, Judge, is.
This is still, in your view, headed toward adoption of both of them by this family, and the family still wants both of them?
Correct. That specific question, Your Honor, I had with foster father 10 days ago, so yes.
All right. I mean, these are terrible and difficult situations.
Certainly is, Your Honor. I would say, Your Honor, they were thriving at the time of trial, and that has continued.
Okay. I also found it surprising DCF doesn't seem to have gotten to the bottom or figured out what these sexualized behaviors, what had caused the sexualized behaviors by one of the children. I think you're familiar with what I'm referring to. And I was concerned with no allegation of prior sexual abuse, at least on this record at all, that those kinds of behaviors were going on. And I was surprised not to hear that someone had been treating them and had sorted something out about them. Go ahead.
It did just appear in the record, Your Honor, without explanation. I do agree with that.
Do you think that DCF needs to know about that before they can make a recommendation of what's an appropriate pre-adoptive home?
Certainly, Your Honor. We all do.
All right. I mean, these aren't really answerable. We do have some authority to do some things based on things that happen after the, after the case ends below. There are cases that have been remanded. It's a pretty gray area. But I don't hear you saying that you think there needs to be a remand for further consideration.
I do not, Your Honor.
Okay. Oh, your time's expired, and I've taken it all up, not with questions, so if there are actual questions. Okay. Thank you very, very much. These are obviously the cases that are some of the cases that are of the gravest concern to us for the obvious reasons. So thank you very much. Excellent arguments, all three of you.